Aloha and welcome. We're going to give it a few more minutes to give others a chance to join the Zoom meeting. Hey, aloha and mahalo for joining. My name is David Zakota. I'm the Fisheries Program Manager for the State of Hawaii, Department of Land and Natural Resources, Division of Aquatic Resources. I will be conducting the public hearing tonight along with the DAR staff at our in-person host sites. It is now 5:33 p.m. and this public hearing is called to order. This is a formal statewide public hearing on proposed amendments to Hawaii Administrative Rules, Chapter 13-95, rules regulating the taking and selling of certain marine resources. The primary purpose of this proposal is to update rules for manini, kala, uhu, and pāpaʻi kualoa or Kona crab, establish rules for kole, and update the chapter with other various housekeeping amendments. As required by law, the proposed rules have been drafted in Ramsar format, copies of which can be found in the announcements section of the DAR website. Those attending the meeting in person may ask DAR staff for a copy. This public hearing is being simultaneously live streamed to the DAR YouTube channel for anyone wishing to observe the public hearing but not provide testimony. For your convenience, the address to the DAR YouTube channel is at the top of this slide, and a link to the live stream has also been pasted into the chat. The purpose of this hearing is to provide the public the opportunity to provide comments in the form of oral and written testimony on these proposed amendments. Approval to conduct this public hearing was obtained from the Board of Land and Natural Resources at their board meeting on May 12, 2023. The legal notice of this public hearing was published in the July 1st, 2023 Saturday issue West Hawaii Today and in the July 2nd, 2023 Sunday issue of the Honolulu Star Advertiser and Hawaii Tribune Herald. Additionally, notice of this public hearing was published on the draft rules and public notices page of the DAR website, where digital copies of the draft rules in Ramsar format can be found, as well as posted on the announcements page of the DAR website. Hearing procedures. First, we will watch a short video explaining the proposed changes to the administrative rules. We will then begin the public testimony period, which will be conducted as follows. Everyone testifying via Zoom was required to pre-register in order to get the link to testify. We will keep registration open throughout the public hearing and will monitor our email in case anyone has trouble registering or joining the Zoom meeting to provide their testimony. However, if you are unable to join via Zoom, you may still provide oral testimony at one of the in-person hearing locations listed in this slide, or you may submit written testimony by following the directions at the bottom of the slide. Everyone testifying in person at one of the host sites should have written their information down on the sign-in sheet provided at the host site. Those attending in person who have not registered but would like to provide testimony can alert the DAR public hearing officer at your in-person host site, and your name will be added to the list. It is important that everyone who wishes to testify provide their name and contact information so we have an accurate record of everyone providing testimony. You will be called upon by a member of the DAR staff when it is your turn to testify. We ask that all individuals attending virtually keep their microphones muted when not speaking. We will take testimony in the following order. First, we will take in-person testimony from people who have been signed up to testify, beginning in Hilo, then Kona, and once all in-person testimony is gathered, we will take Zoom testimony. Please keep your testimony brief and on the subject to allow everyone the opportunity to testify. Each person providing testimony will be given 3 minutes. Please be aware that if you go beyond 3 minutes, I will kindly ask you to conclude your testimony. We are recording this hearing to make a complete and accurate record of the proceedings, so please state your full name and where you're joining us from before you're giving your testimony. Make sure to speak clearly so we accurately record your testimony for the record. Please turn off the live YouTube stream of this hearing while testifying, as it will cause an echo. Please remember to respect the opinions of all testifiers and that this hearing is not an opportunity for accusations or rebuttals. There may be differing opinions. Everyone will have an opportunity to voice their opinion for the department to consider. All testimony should be directed to me, not to the audience. Once again, please note that this hearing is simultaneously being streamed on YouTube. The live stream will be recorded and preserved on YouTube as a matter of public record. Please be aware that by offering your oral testimony today, you're consenting to being audio and video recorded if your camera is on. Let's begin with a short video on the background explaining the proposed administrative rules.
Proposed amendments to Hawaii Administrative Rules, Chapter 13-95, Rules regulating the taking and selling of certain marine resources. Papa'i kualoa, or Kona crab. DAR has identified the need to amend the rules for Papa'i kualoa based on a number of factors. In 2018, a stock assessment was conducted which suggests that the Papa'i kualoa population is healthy. There is currently an annual catch limit, or ACL, in place, and current harvest numbers have been well below the established ACL, indicating that an increase in harvest would be sustainable to Papa'i kualoa populations. Current regulations that prohibit the take of any female Papa'i kualoa result in 80% discard rates due to catch being female or undersized. Additionally, an extended close season will help prevent catch of females with eggs. Current rules for Papa'i kualoa are a minimum carapace length of 4 inches, no taking of females with or without eggs, and a close season of May through August. The proposed amendments to the Papa'i kualoa rules keep the same minimum size of 4 inches, but allows the take of females without eggs and extends the close season an additional month from May through September. Proposed amendments to Hawaii Administrative Rules, Chapter 13-95, Rules regulating the taking and selling of marine resources, manini, kole, kala, and uhu. Pictured here are the fish species with new or amended rules within this proposal. They are manini or convict tang, kole or gold ring surgeonfish, kala or bluespine unicornfish, and all species of uhu or parrotfish. Manini, kole, kala, and uhu are all important food fish. They are important to both recreational and subsistence fisheries, and in some cases sustain commercial fisheries as well. Because of their widespread importance to fishing, DAR wants to take a proactive approach to ensuring that their populations are sustained in perpetuity. Also, increasing non-fishing threats put added pressure onto the resource. Coral bleaching, poor water quality, and habitat loss are just some threats to these fisheries and are expected to get worse with climate change and a growing human population. Fisheries management may not address these threats directly, but will offer these species some relief as future action including land-based initiatives increase. Additionally, herbivores play a crucial role on reefs, maintaining balance and providing the right conditions for corals to flourish. Large-bodied uhu in particular aid in the settlement of larval coral with no redundancy in the ecosystem, meaning there are no other species to fill the role they play within the ecosystem if they are depleted. The current rules for manini are a minimum size of 5 inches. The proposed rule would increase the minimum length to 6 inches to match the upper range of the L50, or the length where approximately 50% of the population has reached reproductive maturity. There is no current statewide rule for kole. The proposed rules include a minimum size for kole of 5 inches. Although the minimum size is conservative when compared to the L50 for kole of 3.3 to 3.9 inches, the proposed minimum size is consistent with the size that most spearfishers harvest kole. Currently, the statewide rule for kala is a minimum length of 14 inches with no bag limit. The current minimum length is consistent with the L50 for kala at just under 14 inches. The proposed rules for non-commercial take of kala keep the minimum size limit at 14 inches, but also include a bag limit of 2 per person per day. As a means to reduce the commercial take of kala while still maintaining the commercial fishery, DAR proposes separate rules for the commercial taking and selling of kala. The proposed commercial rules for kala would require a commercial kala fisher to obtain a separate commercial kala fishing permit, in addition to a commercial marine license, or CML, which is required for all persons wishing to sell their catch. The permit fee would be $100 annually in addition to the fee for a CML, and in order to maintain eligibility for a commercial kala fishing permit, permit holder must have caught and sold at least 100 pounds of kala within the previous year if they had a commercial kala fishing permit within the last 12 months. The proposed rules for commercial kala fishing permit holders are a commercial daily bag limit of 50 kala per permit holder per day, no commercial harvest or sale during the kala spawning season of April through July, an annual catch limit or ACL of 10,000 pounds. When the ACL is reached, the fishery will be closed for commercial harvest or sale for the rest of the year. Additionally, the proposed rules requires dealers who sell kala to register as a commercial kala dealer. With the exception of Maui, the current statewide rules for uhu pālukaluka, uhu eleele, uhu ahu'ula, and uhu uliuli, which are collectively referred to as large-bodied uhu, is a minimum length of 12 inches with no bag limit. The proposed rules for non-commercial take of large-bodied uhu would prohibit the take of uhu eleele and uhu uliuli, the terminal phase blue large-bodied uhu, increase the minimum size for uhu pālukaluka and uhu ahu'ula, the initial phase red large-bodied uhu, from 12 inches to 14 inches, and impose a combined total non-commercial bag limit of 2 per person per day for all uhu species, both large-bodied and small-bodied, mirroring the Maui uhu rules. Again, with the exception of Maui, the current statewide rule for small-bodied species of uhu is a minimum length of 12 inches, noting that ponuhunuhu and yellow bar parrotfish are not regulated. The proposed rule would apply the Maui rules statewide with a minimum length of 10 inches for non-commercial take of all small-bodied species of uhu. Also, as mentioned in the previous slide, small-bodied uhu would be included within the combined total non-commercial bag limit of 2 per person per day for all uhu species. Similar to kala, the proposed rules include separate rules for commercial uhu fishers and dealers. The proposed commercial rules for uhu would require a commercial uhu fisher to obtain a separate commercial uhu fishing permit, which is a separate permit from the commercial kala fishing permit, in addition to a commercial marine license. The permit fee would be $100 annually, in addition to the fee for a commercial marine license, and in order to maintain eligibility for a commercial uhu fishing permit, a permit holder must have caught and sold at least 340 pounds of uhu within the previous year if they had a commercial uhu fishing permit within the last 12 months. The proposed rules for commercial uhu fishing permit holders are a commercial daily bag limit of 30 uhu per permit holder per day, a commercial slot limit of 14 to 20 inches, meaning a minimum size of 14 inches and a maximum size of 20 inches, no commercial harvest or sale during the uhu spawning season of February through May, an annual catch limit of 34,000 pounds. Again, when the ACL is reached, the fishery will be closed for commercial harvest or sale for the rest of the year, and only uhu pālukaluka, or initial phase red-lip parrotfish, is allowed for commercial taking and selling. Additionally, the proposed rules requires dealers who sell uhu to register as a commercial uhu dealer. To illustrate the allowable catch of all uhu species, here are all the species that are proposed to be regulated, which would be all uhu species, both large-bodied and small-bodied. For non-commercial take, uhu uliuli and uhu ele would be prohibited as indicated in this slide. For commercial take, all uhu would be prohibited except uhu pālukaluka.
Okay, we have now reached the testimony portion of this public hearing. As a reminder, the address to the DAR YouTube channel is shown at the top of this slide, and a link to the live stream has also been pasted into the chat. So if you just want to listen into this hearing without providing testimony, you're welcome to log off this Zoom meeting and view the YouTube live stream of the hearing. If you remain in the Zoom meeting, you'll be called upon by a member of the DAR staff when it is your turn to testify. We ask that individuals attending virtually keep their microphones muted when not speaking. And as I mentioned earlier, we'll take testimony in the following order. First, we'll take in-person testimony from people who have signed up to testify in Hilo, then in-person testimony in Kona, and finally, we'll take Zoom testimony. As a reminder, please keep your testimony to 3 minutes in order to ensure that everyone who signed up has a chance to give testimony. If there's extra time at the end of everyone on the list and you would like more time to testify, we will allow those who already spoke to give additional testimony. I'll now stop sharing my screen so everyone providing testimony can be clearly seen.
All right, we have one testifier signed up in East Hawaii, Mr. Gary Beals.
Aloha, please state your name and proceed with your testimony.
My name is Gary Beals, a resident of Hilo, and I wish to testify in opposition of the rule changes. That's a general opposition. I would base this opposition on, number one, faulty assumptions made by Land and Natural Resources, especially in regards to the lack of herbivores, which is resulting in algae overgrowth. They base this, according to Land and Natural Resources, a lack of herbivores by overfishing. I would take issue with this and question that the lack of herbivores is a result of environmental conditions, both from the land and just general overall conditions in the ocean. One of the assumptions is that the lack of herbivores is caused by overfishing. Land and Natural Resources has not provided any information to identify that the areas of algae overgrowth are caused by overfishing. There is no evidence that a cause and effect relationship exists between herbivores and algae overgrowth. The information provided to the Land and Natural Resources, I believe, came primarily from a study done here in Hawaii by a group or an individual called named Nadon. And this was in 2016. The overfishing of the uhu, according to his report, caused the limo on the reefs to expand or increase. And contrary to the Nadon report, uhu are not really herbivores. The uhu eat the coral, but their primary food source is a cyanophyta, or a type of plant that is included within the coral itself. So the fact that, or assumed fact, that the uhu are damaging these is the reef is incorrect. In the Nadon report, of all of the species that they studied, they only had actual scientific data for about 1/3 of the species studied. The rest was just based on assumption.
Can you wrap up your testimony? If we have time at the end, you can provide additional testimony, but your time's up.
Okay, I conclude here, again, in opposition of these based on incorrect scientific data, or
Okay,
assumed.
thank you. Thank you. Troy, is that it for East Hawaii?
Yes, that's all we have for now. Thank you.
Okay, let's move on to West Hawaii.
Great. First up, we have Steve Kaiser.
Good afternoon. My name is Steve Kaiser. I'm a resident of Hawaii. I have sort of a long testimony, so I'll try and cut it shorter. Basically, first off, I'm much in favor of the Kona crab change. This is really an administrative rule. Let's remember that the legislature got rid of the law banning the take of female Kona crabs going on 2.5, almost 3 years ago. This is a statute that still remains on the books. There's lots of reasons that the legislature, we provided information to them of why it was supported by DLNR, and let's go ahead and make it allowable. On the herbivore rules, I'm gonna question the science. Basically, the first large survey cited by DLNR was Nadon in 2017. And yet for the kole, the report stated near equilibrium. I will add many other species listed as near equilibrium, yet has not received the same status from DLNR. I will also question the relevancy of this study, which measures populations for 2007 to 2016. The conclusions were ta'au was stable, ta'ape decline from 2005, suggesting equilibrium. Roy was steady, and clearly anybody who's been on the water will contest these conclusions. Tapi and Toao and Roy populations are exploding on our islands. And I would add that 5 species of species listed in this report, 1 species, low observation, so no data, 2 rising, 1 rising but falling, but still above 2007 levels, and 1 fluctuating but steady. And the methodology was varied and used data from many sources, including DLNR, ASNR, and others in surveys conducted statewide. If we have extra time, I'd like to talk about those other studies that do not conclude the same thing that he did. As far as the rules, I'm not against rules, but I don't think the rules are really addressing it. If you really wanted to stop the excessive take of uhu, we should just ban night diving. Anybody who goes out there and dives on the daylight, they're lucky if they get 2, 3, maybe 4 uhu. I'm not too sure bag limits are even necessary for that. It's the night divers that take excessive numbers. It's not pono and it's not right. The next thing is on the commercial take, this is our first entry by the state of Hawaii into a limited entry fishery. There's lots of missingness. So you have to have a history of kala and uhu, but yet what happens if that person doesn't fish? What happens if new people want to come into the fishery? Are those licenses going to be basically thrown away if they don't fish? Can they be assigned to somebody? Can it be transferred? How does a young person get into the fishery? So I think those things are the second thing is the sizes. The sizes, you know, increasing in size sounds real good, but really we should be looking at slot limits. By increasing the size, we're just continuing to remove our largest and best breeders. No terrestrial farming or ranching or anything, you would take your best breeders out. Also, can somebody really tell me the difference between a 5-inch and a 6-inch fish? If we just let people take the slots in the middle one and leave the big breeders alone, they produce 10 to 100 times more eggs. Natural predation is low on the bigger ones, so we shouldn't add to that. And, you know, let's look at slot limits. I'm not against the rules if that's the way the state wants to go there, but I think we really need to look at doing the proper rules. Thank you.
Hey, mahalo, Steve.
All right, next we have Shane Oconee Nelson. Okay. And then Cecile Walsh.
Mahalo nui for this opportunity to comment on DAR's proposed herbivore rules. My name is Cecile Walsh. I am the community coordinator for the Nature Conservancy Hawaii Island Marine Program. The Nature Conservancy is supportive of the herbivore rules, but opposes the commercial exceptions. The main focus of our program is to support community-based marine management. I've had the honor to work alongside community members in networks such as the Kaikuliana Network, the Maui Nui Makai Network, and the Ka'upalehu Marine Life Advisory Committee that have been striving towards Aina Momona for decades. I feel as if it is my kuleana to support their mission and provide this testimony in support of the proposed herbivore rule package with the deletion of the commercial exceptions. The intentions of these rules are to seek a balanced and healthy marine ecosystem into the future. Including these commercial exceptions is not balanced, is not pono, and will not lead to a healthy, sustainable fishery as intended. Commercial businesses should not have an exception to remove thousands of pounds of limu-eating fish annually, which would further decrease populations of these vulnerable and already overfished species. These rules will be most effective in helping to restore healthy herbivore populations for the next generation if the commercial exceptions for the uhu and the kala are removed from this rule package. Mahalo nui for your time and for this opportunity to urge your approval of the proposed herbivore rules with the deletion of the commercial exceptions. Mahalo.
Mahalo.
Mike Nakachi.
Aloha mai kako, everyone. Grateful for this opportunity to speak and offer testimony for the Division of Aquatic Resources. My name is Mike Nakachi. I come from the Ahupua of Waikoloa on this moku. I just want to think about something and allow folks to reflect. I listened last night on Maui, and I think for many of us that have moku auhau and we're born kind of into a westernized system that allows for commercial things to happen. Some of them are good, some of them are not good. But what I'm getting at is that, DAR and DLNR essentially is the konoiki of a system that has changed. And again, all that we're talking about are, again, public trust assets that are held in perpetuity. Again, that we have to remind DLNR that these are held in perpetuity for one, the people of Hawaii. Number two, they're held in perpetuity for cultural components. And then third, I have to remind everyone that commercial is below those. So here is my dilemma, is that I've been involved with this for probably 30 years plus on the West Hawaii side. And as Steve also pointed out earlier, we're the only place with the WRFMA that doesn't allow commercial collection on scuba at all. And even night scuba is not allowed for taking or spearing of fish. But, these are statewide rules, and am I in support? I'm in support of the Kona crab. But when you break this down, you're putting forth a rule package where you're allowing still an unlimited take of kole. You're still allowing an unlimited take of manini. But when it comes to commercial, the commercial, again, always seems to have an exception. I'm for the rules as they are proposed for the general public, but I would also be opposed to those particular rules as it engages commercial activities or the commercial take of uhu. And also, but here's my big concern, is that DAR already has the palapala, and they know of those people that have taken 340 pounds of uhu in the past year and 100 people. We as the general public need to know this data well in advance. And we feel that if commercial is then allowed, that you then need to have an identifying system of those boats and of those individuals that would be allowed to commercially engage if that was to happen. My big concern is also enforcement. So these are reasons why we need to have public trust resources well vetted within the public domain to then have, whether it's CU for commercial uhu or CK for commercial kala. We're dealing with a fish, and I'm in the water almost every single day. We are cultural practitioners that practice papaku makavalu. We refrain from the take. We kilo constantly on fish, and kala are generational. We have breeders that Steve also mentioned that can live up to 50 years. And when you can allow, I just think that there needed to be a little bit more refinement with the difference between the commercial and this. I know, and this is what also bothers us, is that we have people that are going to oppose these rules because they're going to want status quo. And I applaud DAR for at least trying to limit 50 fish a day. that's quite honorable, but you're going to have hundreds of people or maybe dozens of people opposing that because they want to see what happened here at Ka'upulehu. 900, 800 pounds.
Can you start wrapping
I'll
up
come
your
back.
testimony?
Yeah, no worries, David. I'm going to write some other things here, and I think I'm up next for my son. He couldn't make it, so I'd love to just read what he said in a text.
Okay, can you state his name and then proceed?
Sure. I'm stating on behalf of my son, Kaikea Nakachi. I'm airballing this probably. He would probably do a 30-foot swish on this as a three-pointer. So I'm not as eloquent as my son. And he says he supports the herbivore rules and their intent, but making exceptions for commercial fishers does not align with the intent, and reminds the state public trust resources belong first and foremost to and for the public. Listen to cultural practitioners and recreational folks who are telling them to protect herbivores. After talking to members of the DLNR and seeing the hearings, he says one thing to mention, that herbivores like kala, as I mentioned previously, can live up to 50 years. He knows of fish that both my dad, him, and I have seen that are, I can say, kinolau kupuna, that are on the reefs that we would love to still see and provide to another generation. These kala that were alive when his grandfather was alive, he says, Malama Aina is how we honor the legacy of our ancestors. By allowing commercial exceptions and the other non-pono fishing practices, we dishonor them and we squander their legacy. We want to be able to malama these fish for another 50 years. And when it comes to excuses of fishing methods that kill and create bycatch of bluehu or other herbivores, then these rules allow. Now is the time to realize that that is a part of the problem. It is all more reason to change commercial fishing to not be harmful, which is again the intent of these herbivore rules, to protect the herbivores and what they provide, not to protect commercial self-serving interests. End the statement. Thank you.
Okay, thank you.
All right, last up, we have Charles Young.
Hello, my kako. My name is Charles Young. I reside in Kealia in the region of Kapalilua, South Kona. I'm testifying from Kailua, Kona. I have written testimony, which I'd like to submit, but I'll also read from it, and hopefully I'll have some time after it. This is written on behalf of the Hawaii Island Ahamoku. My name is Charles Young. I reside in Kealia in the region of Kapalilua, South Kona on Hawaii Island. These comments are written on behalf of the Hawaii Island Ahamoku. The Hawaii Island Ahamoku supports the intent for the proposed amendments insofar as they are meant to protect and better manage our marine reef and nearshore ecosystems. However, the Ahamoku is unable to conclude that the measures as proposed or supporting data as presented are sufficiently conclusive enough for the Ahamoku to support proposals that on the surface seem to limit commercial overfishing and that conversely reserve a generous portion of the allowable catch to individual licenses. The Ahamoku does not dispute fish caught commercially that remain in the local market at prices our kupuna and kama'aina can afford, provide an economic, health, and food security benefit for all who live here. The category non-commercial fishers would lump subsistence fishers in with recreational, sport, and all others. In this area, the Ahamoku maintains that demand from subsistence fishers should be the first order of priority ahead of all categories. The DLNR has of recent begun to employ a kapa'akai analysis as mandated by the Hawaii Supreme Court in its Kapa'akai Oka'aina versus the LUC decision of 2000, where decision-making by the department may impact Native Hawaiian practices. The proposal and the precedents that processes like Chapter 91 have had and continue to have on our resources must consider subsistence fisher In arriving at the volume of the commercial take, the annual catch limit is used in calculating daily limits. The ACL is the only indicator available to the agency. The ACL is predicated on data and statistics gathered voluntarily by licensees. Currently, the agency lacks the capacity to assess the true collective take and does not itself collect the empirical data from all users. The Ahamoku is unable to conclude whether the daily limit is a verifiable statistic supporting sustainable management of the resource or just a best guess. The Ahamoku acknowledges that our marine ecosystems are in decline for all the aforementioned reasons, and that additional actions beyond the scope of the DLNR is required to stem or reverse the decline. The additive effects of climate change will also require us to adapt and mitigate impacts. In its outreach, the Hawaii Island Ahamoku received no clear guidance on solutions, but did note that everyone has an opinion and that user groups tend to blame one another. By separating and defining fisheries as commercial or non-commercial, the Chapter 91 processes mischaracterizes or completely fails to capture the legacy of fishing in Hawaii. Hawaii was and continues to be a fish were and continue to be a significant cultural marker for indigenous people. Indeed, volumes of mo'olelo, mele, values and practices have been passed down and are still relevant today as foundational building blocks for subsistence fishers. The Ahamoku finds that indigenous fishermen may identify exclusively as subsistence fishers, but yet at the same time maintain a commercial fishing license so a portion of the catch can be sold to cover costs. That same fisher may fish for profit, leveraging monthly or seasonal cycles and annual runs, has always been the cultural practice. The Ahamoku could rely on a kapa'akai analysis, which may clarify to what extent there is an overlap. The Hawaii Island Ahamoku is recommending that the Division of Aquatic Resources, DOBO and DOCARE, consider conducting a kapa'akai analysis for all sectors affected by licensing or permitting. The number of commercial fishing licenses and commercial boating licenses should be assessed and an empirical database created across all users, including subsistence fishers and true impacts on the ocean resources. The Ahamoku suggests that the DLNR should and leverage its opportunities within the department for more consistent cross-functional collaboration. Mahalo.
Hey, mahalo. Again, if we have extra time at the end, people are welcome to stay and provide additional testimony. You can also submit it as written testimony. Next, we'll go to our Zoom testimony.
Hey, David, we have one more.
Oh, sorry. Go ahead, Chris.
Okay.
I'm Pavel and I'm 7 and I'm Pavel Cooper and I'm 7 and fishermen take fish that they're not supposed to and they take too much and they waste it. What about me?
Oh.
Mahalo. Okay, Chris, any others?
That's it for West Hawaii.
All right, thank you. Next, we'll move on to our Zoom testimony. If you have registered for this Zoom hearing, again, we'll presume that you're interested in providing testimony, and we'll call your name in the order that you've signed up. If you do not wish to provide oral testimony, please indicate so when we call on your name, or you can let us know through the chat feature. So first up on the Zoom, I have Arnold Akau Jr. You can go ahead and unmute yourself. Okay, moving on, we have Donna Goodale.
Hello?
Yes, please go ahead.
Yes, first of all, I support for the most part DAR's efforts to help the herbivores by reducing their take. I do have some amendments I'd like to change on it. I think there should be a bag limit for manini and for kole. And I do not agree with having a commercial take. If we are trying to protect these animals and we're trying to increase their population, and we're limiting someone who is taking fish home to feed their family to only 2 per day, then we should also limit commercial fishermen to 2 per day. There should not be a commercial exception. And there should be a bag limit for kole and manini. And other than that, I support DAR's attempts to protect these species and increase their population. My name is Donna Goodale, I'm sorry, and I am in Kailua, Kona, and I overall support with some exceptions. Thank you very much.
Okay, mahalo. Next up, we have Phil Fernandez.
Thank you. This is Phil Fernandez. I'm a resident of Honolulu, Hawaii, Big Island. I got a message here that somebody wants to start my video. I don't have a video, so I don't know what you're talking about.
Yeah, that's okay.
Okay. So I am in favor of the proposed Kona crab rules. I am opposed to the herbivore fish proposal. I support the intent of the herbivore plan to have sustainable resources, but this particular proposal is flawed and need to be rewritten. It is my understanding that there are 2 reasons why DAR wants to implement these proposed rules. There is a claim that herbivores are being overfished. DAR's justification of this alleged problem is a study by Dr. Mark Nadon, published in 2017 as a NOAA technical memorandum. In this study, Dr. Nadon's analysis hinges on 2 main points: a stock analysis, not specifically a stock assessment, and the use of spawning potential ratio, SPR. Number 2, the other reason cited that the herbivore need to be protected is that they are some sort of protective mechanism to sea level temperature rise, sea temperature rise, which subsequently results in coral bleaching. I do not argue rising ocean temperature. I think it is inevitable based on what we see today. However, implementing the herbivore plan will be ineffective to reverse this inevitability. Let me address the 2 reasons why the 2 reasons are flawed. The native study was never done as a stock assessment. Dr. Nadon states that the data that he found to do the study was poor. In the case of uhu, that data were not available at the species level. He had to manipulate the data to get the number that he could use. This is stated specifically in the technical memorandum. The data were from 2009 to 2013 and were spotty, as DAR knows. This fishery is data poor, and no one will argue that point. The Nadon study also depends on what is called SPR, a tool that fisheries scientists use, but it's not the method of first choice, as it requires biological data of the species, which again, the study admits that it does not have. There needs to be data on the number of eggs that a female has compared to its weight. For much of the data in Dr. Nadon's study, the data does not exist. So Dr. Nadon guessed on what the SPR should be. SPR data, admittedly, is hard to come by. Not only does species biology have to be accurate, the entire stock must be assessed. Scientists also know that the number of eggs per female are highly dependent on water temperature and available nutrition in a particular area. Therefore, to use data that were collected in one area cannot be extended to the entire island chain. Thus, I feel that the dependence on the Nadon study is wrong and is giving a wrong picture to DAR for the state of the herbivore fish. The second reason given is that herbivores are related to saving the coral reef is also flawed. Scientists like Dr. Charles Darwin recognize ecological conditions change over time and only the most fit species survive. This is called ecological succession. Many nature resource managers have adopted the idea of ecological succession as a way to understand that the ecology adapts. Yes, in some cases, species may die, but in other species will fill in and thrive. The water temperature in Hawaii may rise and may hit temperatures equivalent to the islands and reefs near the equator. Our reefs may end up looking more like reefs like Wake Island, Marshall Islands, Nauru, or Kiribati. These islands have different coral and a thriving ecosystem. Additionally, to point out ecological succession, the USDA 2018 published a guidance on wetland ecology, adopting ecological succession as a method of managing. So they recognize the change in climate and are adapting to that. Another example.
Could you wrap up your testimony?
Yeah, 2 more sentences. Another example is when the fresh water stopped flowing into Mauna Lua Bay due to the construction of the highway. Ama disappeared, but was replaced by O'Eo, and that was a natural event that occurred, and O'Eo are thriving. Wildfires in Western US after fires, wildfires, the trees that are more resilient to drought are replacing the trees that need rainfall. So these are all species that are adapting to the environment. And I think that coral reef will also adapt to climate change. And just wanted to point those things out and want DAR and DLNR to consider those facts as part of their rulemaking. Thank you very much. Appreciate the time.
Okay, thanks, Phil. Next up, we have Uilani Naipo. Aloha.
Aloha, David. Uilani Naipo, linear descendant of Miloli'i Kapalilua, Miloli'i CBSFA Marine Management Program Administrator. Mahalo nui to DAR for holding these public hearings and the tremendous effort put into this work. I'd like to frame this afternoon's testimony today to focus on my support of the non-commercial rules with recommendations and comments. And I'll just leave a brief statement regarding the commercial rules that I am not in support of those. And I probably will be back tomorrow or Monday to provide additional comments and recommendations. I truly support the intent of it though, and yeah, I'll come back to that. Regarding the non-commercial rules, herbivore rules, after hearing testimony from Molokai Nui Ahina, I wish to express my strong support of moku or island-based rules. This may be thought of as a huge task, but I have to say, mai maka'ui kahana, maka'ui kamoloa. We cannot be lazy about this. You know, we can look at Maui Nui Akama that set the precedence in 2014, making amendments to the rules related to the herbivores island-wide. And that's the chapter 95.1. That's exactly what it is. It has the statewide rules and it has island-based rules. So the framework is there. The HANA is very, very large. And even the enforcement may be a tackle. But here we have, you know, at the community level, this is what Miloli'i did just 1 year ago today. So 1 year to the day, governor signed the rules to promulgate for our CBSFA. It's a HANA Nui, and I think if Maui Nui Kama can do it for their area, being of the place and speaking on behalf of the people of that island, then this is totally possible to carve out for Molokai Nui Ahina. And I think if a thorough kapa'akai analysis had been done, we would not have heard very loud and very clear their concerns yesterday. So I'm in full support of moku island-based rules. Reflecting the traditional practices, there is no real big difference. Proportionally, whether a Hawaiʻi fishes for his family or for his community. Yes, there is more that is taken to feed the community, but proportionally, they're the same. And so, you know, I applaud those that have committed to their testimony about not allowing for commercial take. So overall, I do support the herbivore rules being proposed. They are consistent with what we've implemented in Miluli ECBSFA and Maui rules. I commend DAR for doing this hard task, and I'll be back to provide comments on the commercial. Mahalo.
Hey, mahalo. Next, we have Len Nakano. Len, would you like to provide testimony? If so, you can unmute yourself. Okay, is there anyone else on the Zoom meeting that has not provided testimony that would like to? Okay, hearing none. We can go back to the East Hawaii in-person hearing. Troy, is there anyone else there that showed up that would like to give testimony?
No other testifiers on our end. Thank you.
Okay, thank you. Going back to West Hawaii, Chris, is there anyone that would like to provide additional testimony in West Hawaii?
No new testifiers, but I have a couple of people who previously testified who would like to. No, we have one more. Okay.
Aloha.
Hey, aloha, Shane Oconee Nelson, lineal descendant of Kealakekua Bay, also the president of Ho'ala Kealakekua Nui, a nonprofit that supports fisheries management in Kealakekua Bay, or the MLCD area. I'm here we support the intent of this particular proposal, the intent for herbivore management. We also do have concerns about the commercial entity, and possibly tomorrow we'll be providing more comments. But I did want to reiterate the importance of applying the kapa'akai analysis. I think that as Miluli had mentioned, I had a conversation actually with Uilani earlier today about taking the time out to really be thorough and concise in the work. If we just take the time out to thoroughly do the proper consultation, I think we'd be able to come up with better solutions and promulgating more pono rules that would govern our fisheries. So with that, we support the intent of the herbivore management, but we do have grave concerns about the commercial entity piece within the proposals. That's about it. Yep. Mahalo nui.
Okay, mahalo. Would anyone else like to add to their testimony from West Hawaii?
Steve Kaiser first.
Thank you for allowing additional testimony. You know, I already, Phil already went through the NADAR data. I already mentioned some of it, but I'm not too concerned about the whole state. I'm concerned about where I live, which is on the Big Island, especially on West Hawaii. So I want you guys to be aware that there's actually other studies of the populations here, and I'd like to just go through them. First, we have the Seattle Aquarium, which had surveys West Hawaii in 2009 and 2017, which showed increasing numbers of all species, including kole. This methodology was quite different from the others in that they used videos and then swim the transit line, take the videos, and then go back and separately pull out the numbers. The next one we have is Asner's study in 2020. West Hawaii study data collected 2008. That was in April and October, 2009, February and April, 2011, August and September, 2014, October through December, and 2018, February to April. Surgeonfish, wrasses, and goatfish, and included species over 6 inches, and kole and manini over 4 inches. It did not count all fish, only selective fish. Its conclusion was significantly greater biomass in 2008 compared to 2018. Similarly, for herbivores, browsers and grazers, there were significant more fish in 2008 compared to 2018. For browsers, there was fairly steady decrease in biomass, while grazers showed significant decline in biomass between 2014 and 2018. Scrapers, on the other hand, showed variable increases and decreases throughout the survey years, with the greatest biomass in 2014. So we have 2 surveys saying increases, one survey that is questionable as a nadir study, and the accuracy, but does not show equilibrium, with only 1 species of parrotfish falling, but still above 2007 levels. That was a NADAR study. Then we have a study which has varied seasonability and very selective size limitations. As a fisherman, I know seasonality is real. As a scientist, selectivity can often be limiting. Both surveys, ASNR and NADAR, talk about bootstrap and Monte Carlo formulations. Those types of things are done when there's lack of data. It's interesting that ASNR also mentions that 2014 was up after there was a ban on spearfishing, but yet his formulas, both Monte Carlo and bootstrap, didn't change. With admittedly that there's less pressure, but the formulas never changed. On the west side of Hawaii, we have the highest numbers of FMAs and regulations in all of Hawaii, and even more in the works, many in place for years. Should we conclude that they have done nothing, or that the data of biomass is not correct and they are doing their job of protecting the resource? That said, if the pressure of others to not look at the data with an objective eye and propose new regulations should also be subject to the same scrutiny. Increasing size limits, which means we're reducing the largest and most productive breeders, makes little sense. It fosters a sense of trophy hunting, which is not productive. Instead, we should look at slot limits. Smaller individuals mean our breeding stock is preserved and recruitment will be the highest. Then we have limits on numbers. I would remind all our locals that limiting numbers don't take into account our culture of serving fish for our important cultural milestones, first luau's, graduations, weddings, and anniversaries. So again, is a science supporting this large cultural change? And while I'm talking about culture, taking uhu at night is not culturally appropriate. It is not pono. And the only way we can take significant numbers of parrotfish is to spear at night. As such, it should be banned. And I will add, for enforcement reasons, easily enforce. Banning night diving would clearly be a way to preserve numbers and be culturally appropriate. Now the commercial catch being proposed. Commercial fishermen perform a very important function. They feed people. And while many will condemn those that fish commercially, those fishermen are like our farmers and hunters. They monitor their stock, they harvest only when numbers are up, and are some of the most conservation-minded people. No, they are not preservationists. Neither are they raping or killing our waters. To say so would to condemn all farmers and hunters and gathering based on only a few. And if in these hard times where many work multiple jobs, they perform a very important function, feeding those who can't fish. However, these new rules being imposed will be Hawaii's first entry into limited fisheries. And so I would caution all that some heavy thought should go into this. Qualifying is a good thing, but then how do new fishers come in? How are licenses passed on, or should a fisher leave? If the idea is to slowly phase out commercial fishers by limiting licenses with no future plans, that is a very dangerous precedent. In closing, I'm sure you'll hear much from those who believe that fish should not be caught or eaten. I'm sure many of them against hunters and ranchers. You'll also hear about the ocean is our icebox and is only to feed our ohana and not for commercial purposes. To the first, I'd say that is a personal choice, but that choice should not be imposed on others. To the latter, I grew up where fishermen were honored and looked up to when they caught fish and sold fish, and every commercial fisherman gives away fish. That has not changed. However, those that do not grow up with that culture has influenced those who have. And I'm ashamed to say is another loss of Hawaii culture. So in closing, please look heavily at the science. Look at the proposed rules and the imposition of limits justified and are not so proposed rules the right path. I would say no to all. Thank you.
Okay, thank you, Steve.
Aloha again, Dave.
Aloha. Go ahead.
3 minutes is not enough time.
Yep. Now you have
Okay.
more than 3 minutes, so go ahead.
Okay, thank you. I just want to leave with an olelo no eao. Ka ia I maona ai ka menehuni. And translated means the fish that satisfied the menehuni that he ate. And in the Kona, the menehuni gave fish to his friends because the friends built him a canoe. So when I talk about the cultural aspects of fish, there was a system in place where it was reciprocal. They didn't just take it and go profit on their own. There was reciprocal. And in trying to define this commercial aspect, there's a certain amount of it that is reciprocal, as I mentioned. And let's call it something different than commercial, because I think we've tagged commercial with for-profit only. But those who reciprocate in the community, I think, have that place. And again, not ahead of the subsistence fisher per se, but I think that's a different definition. The corporate fisher, on the other hand, I think is a little different. You know, they're selling into mass. They're selling into, to feed or for profit. Eventually, it ends up feeding somebody, but it doesn't reciprocate back into, the neighborhoods from where the fish are taken. So I wanted to clarify that, but again, 3 minutes is not enough. But mahalo for your patience.
Hey, mahalo.
Aloha, Dave, again. Just to expand on what was just spoken, what Charlie mentioned, is I think when we talk about things, we're directly concerned about how this affects our moku and how it affects West Hawaii. But the moku as a whole, for many of us, we have the opportunity to papaku makawalu around the entire moku. But it is my understanding that you, as an agency, already have the data that there is only one commercial fisherman that would meet the requirements on our moku, correct? If I'm wrong, we need to know this. The reason why I mention this is that it has already been mentioned to us in several meetings that there is just one fisherman. When we talk about place-based management and you talk about things such as we have infrastructure, as Charlie mentioned, with Ahamoku, but with the Kapa Akai analysis, if that one commercial fisherman was allowed in this moku, it's the same as a lot of commercial licenses, such as Dobor. Dobor then issues a license, commercial license, that is just from Upolu Point to Kalai. That operator stays within that zone and they can conduct their business. I would recommend that if commercial was ever allowed and in these type of herbivore rules, that the people that have the data on those specific mokus, whether it's Kauai, whether it's Maui, whether it's our moku, that some people will not agree with this, but it is a way of a konoiki. You folks are the konoiki. You need to then say that that particular fisherman, if they're allowed, should only be in that particular area that they're supposed to take fish. So if a guy is from this moku and he goes to Hana, is that allowed? And he goes and takes 50 kala from there. What I'm getting at is you need, when these permits are then developed, you're going to need to have some kind of mechanism that's easy to enforce and that those people will be identifiable by their boat. Just same as we have done for 30 years with AQ, the same that things have been done in the past. You need some way that the konoiki grants that permission. It's like me, if I go to Kauai or I go to Ni'ihau or I go anywhere, I'm asking permission. We need the same type of reverence that was done, culturally appropriate, by asking permission. If someone is going to have that exemption in this process, they need to then be noted and they need to be kept within boundaries. We don't want 40 fishermen from another moku coming here and then pounding our resources. Those are just things that need to be addressed, and konoikis would have done that in the past. So because we're living in a Western way and a Western way of doing things, we need to not forget our past that will then help direct us in the future. So I think that needs to be noted. Appreciate the time and thanks for the extra opportunity to speak. Thanks again, Dave.
Okay, mahalo, Mike. Anyone else in West Hawaii?
I believe that's everybody.
Okay. Anyone else on the Zoom meeting that would like to add to their testimony or did not get a chance and would like to testify? Okay. Seeing none. We'll continue. Persons unable to attend today or wishing to present additional testimony may mail written testimony to us by Monday, August 14th, 2023. Please mail testimonies to the Department of Land and Natural Resources, Division of Aquatic Resources, 1151 Punch Bowl Street, room 330, Honolulu, Hawaii 96813. Written testimony may also be submitted by email to dlnr.aquatics@hawaii.gov. Those addresses are listed at the bottom of this slide. This is the projected timeline for these rules after this public hearing. The dates are estimates, assuming that no significant changes to the proposal need to be made based on the testimony received. If changes do need to be made, then the timeline would get pushed back. Based on the testimonies presented, the department will submit its findings and recommendations to the Board of Land and Natural Resources. If approved by the board, the Department of the Attorney General will conduct a final legal review. If approved, the proposed rules will be given to the governor for his final approval. And should the governor grant approval, certified copies will be filed with the Lieutenant Governor's office, and after 10 days, it becomes effective as law. Are there any questions regarding this process? Okay, seeing none, on behalf of the Board of Land and Natural Resources and the Division of Aquatic Resources, thank you for attending this public hearing. It is now 6:44 p.m. and this public hearing is now adjourned. Mahalo for taking time out of your day to participate in this public hearing. Aloha.